let's get then to the main business of order tonight. Our keynote speaker has a legal career spanning a number of decades. Started off in 1987 with her appointment as a public prosecutor in Tabanchu. It's 37 years that she has been a legal practitioner. She served as a legal profession, as a prosecutor rather, attorney, arbitrator, and a lecturer. She was appointed as military judge in 2004. She acted as the acting judge of the High Court on an ad hoc basis between 2005 and 2008. She took a permanent appointment at the Free State Division of the High Court in July 2008. She also served as a judge of the Labour Appeal Court, an acting judge of the Competition Appeal Court, and an acting justice of the Constitutional Court for 2 terms in 2015. She was appointed as the first female judge president of the Free State Division of the High Court of South Africa in 2015, and served in that capacity until the 1st of June 2018, when she joined the Supreme Court of Appeal. She was appointed as the president of the Supreme Court on the 1st of June 2023. There's a lot more I can say about our esteemed keynote speaker tonight, but Justice, if you'll allow me to pause it there and ask the room to please stand on your feet. Let's give her the warmest round of applause we can give her. She says she doesn't like talking in front of journalists, so if we're not nice, she might only speak for 5 minutes. So we have to let her know that she's in good company and she's absolutely welcome on this platform. Judge President of the Supreme Court of Appeal, Justice Molemela.
The leadership of SANEF, the executive of APSA, all the sponsors of SANEF, journalists in the room, distinguished guests, ladies and gentlemen, good evening. It is a profound honor for me to stand before you this evening as SANEF celebrates 30 years of democracy and media freedom in South Africa. Kathy is right. There is a whole lot to celebrate about our democracy and the 30 years since the advent of that democracy in 1994. And the evidence of the strides that have been made in those years is clear from the judiciary. And as she correctly pointed out, the 2 highest courts in the country are headed by females, but that's not the end of it. The majority of judges president of the different divisions are females. So a lot has been achieved. I've been requested to say a few words on challenges in the digital age to media freedom and the judiciary. I stand here before you tonight as a substitute for the Chief Justice Mandi Samaya, who could unfortunately not accept your invitation to be the keynote speaker tonight on account of exigencies of her office at this point in time. I must confess, and I mentioned this to a few people in the holding room, that I've made a few speeches, not a few actually, and many, in my capacity as the Chancellor of the Central University of Technology, and in my capacity as the Judge President of the Free State High Court, as well as the President of the Supreme Court of Appeal. I must really confess that I'm filled with a measure of trepidation tonight, because the audience largely consists of members of the media. I have always shied away from the media, largely because back in the day as youngsters, our teachers used to caution us that, quote, the media will make you and then break you, unquote. So obviously I wanted none of that. But of course, I could not refuse when my boss, and I say this fondly when I say boss, when she requested me to do the honors. I agree, I'm old school, and there's no request that I can ever refuse when it comes from my boss. As a matter of fact, when I served articles of clerkship, I served them under the late Jake Molloy, who was an attorney back then. I got to the bench before him. After a few years, I encouraged him to make himself available, and he joined the bench. And so on the bench, I was actually his senior. But in my mind, he was still my boss, because he used to be my boss. And so each time he walked into my chamber, I would stand up. And each time he phoned me, even if it was not a video call, I would actually stand up. And so I think he knew, the esteem, the high esteem in which I held him. And maybe sometimes he took advantage of it, I don't know. But I do remember that he knew that when he walked into my chamber and I was on the phone, I would immediately terminate the call. So one day he came in and I was speaking to the Chief Justice, and so I signaled to him, "It's the Chief Justice." And then he took a seat, crossed his legs and said, "Well, then tell him to finish quickly." Yeah, may his soul rest in peace. So apprehensive or not, here I am. I must, as I usually do, start this speech with what I call a disclaimer. And it is this, that from my point of view, asking a judge in active service to give a keynote address may sometimes be a disservice to an audience, because he or she may not meet the expectation of the audience. I'm looking for Kathy, I can't see her. Oh, there she is. I know she created a lot of hype. And this is exactly what I mean. Since judges are known to squarely deal with issues raised in their cases, and that they mince no words when doing so, I mean, in the text of our judgments, we call a spade a spade. The expectation, therefore, might be that a judge would not, in the course of giving a keynote address, pull any punches in giving an opinion on topical issues. This does not mean that we as judges do not have personal views. Of course we do, because in the course of executing our duties, we hear things, we see things, but some of them cannot be mentioned in our judgments simply because they were not legitimately brought to our attention in compliance with the constitutional imperative of a fair trial. Under those circumstances, we bite our tongues and wait for the right case with the right facts and evidence before we can formally express ourselves on the issues that have been raised. This is because the judiciary is reactive by its very nature. As I see it, our judicial code of conduct does not allow judges a lot of room to maneuver in relation to what they can say off the bench. And you will say off the record. So depending on the circumstances, when we are invited as keynote speakers, we end up erring on the side of caution by saying less than what we otherwise would, with the attendant risk of merely stating the obvious. There's a view that the judiciary should be, quote, ring-fenced or quarantined from conflicts, unquote, and refrain from being involved in controversies through extracurricular statements made by judges, except in relation to proven facts which are already in the public domain. I subscribe to this cautious approach, even though I am fully aware that journalists have different views, divergent views regarding the circumstances under which judges may safely make extracurricular statements. I guess the jury is still out on that aspect. I know that was quite a long preamble, but it needed to be put forward in my view. Ladies and gentlemen, I'm aware that the relationship between the media and the judiciary and the interdependence of these two institutions is an aspect that was comprehensively traversed on this platform last year. I will therefore not traverse the same ground today, save to acknowledge that without an independent judiciary and media, our democracy would probably collapse. Today, the theme of this auspicious event is 30 years of democracy, a journey of freedom and the unyielding power of the media in South Africa. Even in moments like these, when we can pat ourselves on the back for what media freedom has achieved in our country in the past 30 years, we still remember the tyranny that preceded this freedom, and rightly so, for it is these sad memories that make us appreciate the true value of media freedom. So allow me to go back in time, if only for a bit. We remember a time before 1994 when accurate and truthful information about the state of our country was not as accessible as it is today, and how media crackdowns and calculated propaganda were the norm. We recall how attempts at disseminating accurate information regarding abuses of power, inequality, and the atrocities that a significant part of our nation was subjected to were met with swift crackdowns. We remember Donald Woods and Steve Biko, and how these two anti-apartheid activists were targeted by the apartheid government, tragically leading to Biko's death and Woods being banned from reporting and later having to flee the country, also rightly acknowledging that there are many more journalists and activists who suffered similar and worse fates. We recall how having access to accurate information and sharing it displaced people, resulted in detentions without trial, and had deadly consequences with impunity. But despite the apartheid government's best efforts to eradicate the journalistic efforts of those activists, the information still reached the target audience in one way or another. We remember the time when the dissemination of truthful and accurate information would lead to the banning of publications. Yes, there was a time when media freedom was merely a dream that existed alongside our dream for freedom from all other forms of oppression and a deep yearning for a democracy. Today, we live in a country in which media freedom is, by all accounts, jealously guarded. Given our history, we can indeed attest to how a free press is a vital tool to the sustenance of democracy. What an arduous journey it has been to get where we are today, and how privileged we are to live in a country in which freedom of expression is enshrined in our Constitution. In the context of the media, freedom of expression seeks to balance the rights of reporters and those being reported on so as to ensure continued access to accurate information for all. This means that journalists must present news in context, ensuring balanced reporting that contains no distortion and exaggeration. In particular, they must give all sides of a story a fair hearing. This is what ethical journalism dictates. I cannot overemphasize the importance of hearing both sides of the story. This principle is so sacred. I know now I'm getting into dangerous territory because I'm going to refer to the Bible, but I do read it. So allow me to refer to it as I would refer to any other book. Based on my reading of the Bible, I know at least 2 examples of how God was prepared to hear the other side of the story in circumstances when he, as an omnipresent being, obviously already knew the answers. In the first story, it is stated that after Cain had killed his brother Abel, God still asked him where his brother was, even though he knew that he had killed him. In a different story in the same chapter, we know of Adam and Eve who lived in the garden and were told not to eat the forbidden fruit. And one day they did eat the forbidden fruit, and then they hid in the garden. And obviously, God, being omnipresent, knew what had happened. He still asked Adam where he was. And when he said he was hiding, he still asked him why he was hiding. So it is of significance to me that beyond the religious realm, long before the advent of the Constitution, our law in South Africa recognized the audi alteram partem rule, which means, loosely translated, listen to the other side. It recognized it as one of the primary principles of natural justice. As to whether this principle was always applied by our courts in the past is a debate for another day. We are truly privileged, ladies and gentlemen, to have a constitution that discourages propaganda, incitement of violence, and any attempts to promote hate-centered advocacy based on race, ethnicity, gender, or religion that constitutes the incitement to cause harm. In Khumalo and others versus Holomisa, the Constitutional Court described the right to freedom of expression as follows, and I quote, "The right to freedom of expression is integral to a democratic society for many reasons. It is constitutive of the dignity and autonomy of human beings. Moreover, without it, the ability of citizens to make responsible political decisions and to participate effectively in public life would be stifled," unquote. Over the years, we have had to move with the times. Alas, with the advent of the digital age, a fly landed in the ointment. In this modern era, we face a new challenge, the social media terror of misinformation, disinformation, propaganda, and threats for speaking up. The coarse, acute awareness of the shift that came with the dissemination of information in the digital age was captured as follows in the case of Fundraiser versus Media 24 Limited and others. And I quote, "For even as we grapple with television in the courtroom, there are many, particularly young viewers, who are increasingly turning to the internet to keep up to date with news and current affairs. Many people now use social media as their main source of information, resulting in a shift in how information is disseminated and received. As McLachlan CJ observed, the explosive growth of new media signals a shift in who reports on legal proceedings. Court decisions may no longer be the preserve of trained professional journalists. Anyone with a keyboard and access to a blog can now be a reporter. And who is to say they are not? Some bloggers will be professionals and academics providing thoughtful commentary and analysis. Others will fall short of basic journalistic standards. Will accuracy and fairness be casualties of the social media era? What will be the consequences for public understanding of the administration of justice and confidence in the judiciary? How can a medium such as Twitter inform the public accurately or adequately in 140 characters or less? If witness or juror contamination is a concern with television, is it not even more so with ubiquitous social media accessed or received automatically via a handheld device? Unquote. So the reference there is made to Twitter that was long before the days of X. It is indisputable that the abundance of data in the online space, which has increased exponentially due to the algorithm-based technologies, poses serious risks to privacy. Indeed, the reality is that a click of a button potentially makes us vulnerable to misinformation and disinformation. This brings to mind a statement attributed to Winston Churchill, which still rings true today, that, and I quote, "A lie gets halfway around the world before the truth has a chance to get its pants on," unquote. Misinformation, and this statement was made long before the advent of social media. Misinformation and disinformation are so easily disseminated in the digital space that no matter how strong our constitutional safeguards may be, we may still fall prey to the snares of propagandists who seek to undermine the Bill of Rights that constitute the fruit of our hard-won democracy. An example that comes to mind is fake news on social media platforms. It is concerning to see the ease with which falsehoods are circulated on social media platforms without any real consequences. Lately, we have seen an increase, and the gentleman from APSA alluded to this. We have seen an increase in AI-generated deepfake content. Fake news is worrisome, to say the least, because it has the propensity to threaten not only the very essence of media freedom, but to reverse the gains that were made in respect of the right to privacy, which in turn impacts the enjoyment of all other freedoms enshrined in our Constitution. In her book, entitled The Smear, which was authored in 2017, Cheryl Atkinson, an American journalist, alludes to some of the digital age challenges that allegedly bedeviled previous election campaigns in America. She says the following in relation to how social media can be used for ulterior motives, and I quote, "As social media has become an unavoidable part of modern life, it has proven the perfect conduit for mass astroturf campaigns. But in truth, astroturf has been a part of the smear playbook for years. Plainly speaking, AstroTurf is when political, corporate, or other special interests disguise themselves and try to represent their causes as being genuine groundswells of support by ordinary people. AstroTurfers write blogs, use social media, publish ads and letters to the editor, pay people to form protests or demonstrate as crowds, or simply post comments online to try to fool you into thinking an independent or grassroots movement is speaking. They use college professors and scientists, non-profits, government, doctors and university researchers, public officials, news, and scientific publications. If there's a way to co-opt a mode of communication or a group of communications, they have figured out how to do it. The whole point of AstroTurf is to try to give the impression that there's a widespread support for or against an agenda when there is not. AstroTurf seeks to manipulate you into changing your opinion by making you feel as if you are an outlier when you are not. We like to think of social media as a place where ideas are freely exchanged, where controversial voices and ideas can be heard, a fast-paced Wild West dynamic where manipulation of the message would be difficult to accomplish. But a peek behind the curtain exposes a reality that's far different. And the plain fact that people don't think they are as easily fooled on social media makes them easier to fool. In reality, the internet and social media have given AstroTurf campaigns the opportunity to flourish. While ideas may flow freely online, they are often anonymous, with no sense of who's actually behind the account. After all, it is easier to smear someone when you never have to show your face, or as it often turns out, you don't even have one, unquote. Although one cannot vouch for the veracity of all the writers' statements, we know for a fact that the judiciary has in the past been a victim of social media smear campaigns, and that criminal investigations revealed that fake accounts and pseudonyms were used to besmirch members of the judiciary. Fortunately, the media did not add fuel to the fire, and so the fake news did not gain the traction that the propagandists had hoped for. For this display of ethical journalism, which puts a high premium on verification of information in compliance with the press code, our journalists must be commended, and so I commend you. However, we should not drop our guard as misinformation continues to be an ever-pervasive threat. It behoves our journalists, regardless of the media agency or house to which they might be affiliated in whatever form, to respect the rights of individuals and, by extension, the right of the judiciary with accurate reporting practices. The rapid spread of false information before any remedial interventions can be made undermines both the credibility of the media and the judicial process. Journalists and other institutions, including the judiciary, face hacking, cyber attacks, and harassment online, which constitute an existential threat to our democracy. The reality is that despite constitutional safeguards, the media and the judiciary still face challenges emanating from the widespread use of digital platforms, as many individuals feel entitled to take advantage of anonymity by saying anything they wish, fact and fabrication alike, from behind a screen. What should we do about this? Our recourse is the Constitution. It remains the Constitution. These challenges require a fair balance between allowing technological innovation to flourish and safeguarding democratic principles like free speech. Although the right to freedom of expression is a cornerstone of our democracy and fosters informed public discourse and constructive debate, it is evident that there is still considerable contestation over the exercise of the right to freedom of expression. Section 16(1) of the Constitution of the Republic of South Africa protects the right and provides that everyone has the right to freedom of expression. Section 16(2) provides, however, that the right does not extend to three categories of excluded expression, namely propaganda for war, incitement of imminent violence, and the advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm, which is colloquially known as hate speech. Thanks to the judgments of the Constitutional Court, all courts are now consistent on the interpretation of this right. It is an added victory to freedom of speech that the Prevention and Combating of Hate Crimes and Hate Speech Act 16 of 2023 came into operation on 14 May 2024. One of its many objectives is to provide for the prosecution of persons who propagate hate speech. In terms of this act, any person who intentionally publishes, propagates, advocates, makes available, or communicates anything to one or more persons in a manner that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to promote or propagate hatred is guilty of an offense of hate speech. Although criminal prosecutions have in the past been instituted successfully based on other pieces of legislation, it is hoped that the express criminalization of hate speech in terms of this act will serve as a deterrent and stem the tide of fake news. Despite the challenges I have alluded to, some benefits have been derived from social media. A practice that has become common in many high-profile cases is for journalists and members of the public attending a hearing to use social media to share information about the legal proceedings on platforms like X and Facebook in real time. Live streaming of proceedings such as those of the State Capture Commission were beneficial, as the nation could, in real time, get a first-hand account of all allegations that were being made at that forum. This, to an extent, denied propagandists an opportunity of distorting facts on social media in between news bulletins. The useful side of social media platforms must therefore be embraced. Indeed, there have been instances in which it rightly put a spotlight on oppressive tendencies in other countries in which the right to freedom of expression does not enjoy the same protection as in our country. We should therefore be careful not to throw the baby out with the bathwater. Although transborder nature of the internet has in the past presented significant legislative and judicial challenges for legal and institutional frameworks in relation to complexities such as disinformation resulting from fake posts, cyber threats, and e-violence which results from trolling and hate speech, I believe that our Constitution, together with principles laid down in our country's press code and provisions of various statutes, have provided us with the necessary armaments to meet these challenges head-on. It is evident that judgments of the Constitutional Court, including the fairly recent judgment of Kwelani versus South African Human Rights Commission and another, serve as sufficient jurisprudential backdrop against which claims based on violation of rights in the digital space will be adjudicated. Recent judgments from our courts in respect of claims predicated on the violation of the right to freedom of expression through social media platforms, attest to the fact that South African courts have managed to keep up with global developments in the digital space. Moreover, the conversations that the South African judges have with their counterparts from other jurisdictions at international seminars give us an opportunity to contextually scan the global environment, thereby assisting us in navigating some of these complexities by forging our own solutions which are in conformity with our constitutional values. It has also been gratifying to hear from our colleagues in other jurisdictions that some of the judgments of our courts here in South Africa have given them useful insights on how to resolve their own challenges in their countries. This means that South African courts are up there with those considered to be the best of the best in the world. From my point of view, there is no lacuna in the legislative framework as seen from the prism of our Constitution. Our courts have already demonstrated in a plethora of judgments that they continue to uphold free expression and that they take seriously the responsibility to protect the media from slap suits designed to impair their freedom of speech. No one should have the carte blanche to undermine our Bill of Rights with impunity. We are also aware that online access to information has resulted in many newspapers struggling to adapt to the new digital landscape, leading to a decline in print sales, which in turn led to the withdrawal of certain publications. And I will not say this is probably why you are having this fundraising. It is for this reason that there's a need for a fair allocation of state subsidies in the media markets to support independent media and for such allocation to be subject to judicial review. Today, I stand here to reaffirm that as the guardian of the rule of law, and by extension, the Constitution and the last line of defense, the judiciary is fully committed to its role in supporting media freedom. As I conclude, ladies and gentlemen, I consider it to be incumbent on all of us to ensure that the information we share is accurate, helpful, and aimed at the development of society instead of polarizing it. We know that your job as journalists, the job that you do as journalists is no small feat. As foot soldiers on the ground, we urge you to continue to follow your vocation and help us create a society that will stay on track and not allow our nation to be sidetracked by malicious individuals who have an agenda to misuse social media platforms by peddling narratives that are intended to destabilize our democracy. I trust that this speech has reaffirmed the judiciary's commitment to the protection of the right to media freedom, and that those who seek to abuse that right will be held accountable. This augurs well for the achievement of the 17 United Nations Social Development Goals to be achieved by 2030. It bears reiterating today that opinion number 7, which was issued by the Consultative Council of European Judges, noted that the media can sometimes intrude on people's privacy, damaging their reputation or undermining the presumption of their innocence. My gentle reminder to you is that as journalists, you are enjoined to be impartial. I dare say that in that role, you have less constraints than judges when it comes to speaking out. That said, in telling it like it is. Be careful not to use your pen or keyboard to unjustifiably publish information that is bound to harm or destroy. I thank you.
Thank you so much for that, Justice Molemela. I'm tempted to say thank you for the wonderful and measured address that you gave us, but I think I would be doing it a disservice calling it an address. It was more of an exposition on the theme that we gave you tonight. And anybody who disagrees with me must go to her referencing, and then we can have the debate when we are done. I mean, I don't think I've had a keynote that has been as referenced as yours was. Clearly, this is the reason why you are the president of the Supreme Court of Appeal. Let's give her a round of applause once again.